Joining us now with more insight on how this case could affect you personally is Professor Leslie Garfield Tenzer from the Elisabeth Haub Law School at Pace University. Professor, thank you so much for your time today. Let's just start and catch our viewers up to speed with the actual language in Section 230. I want to pull that up and read that for people. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider.
It's a lot of providers.
A lot going on there. So in layman's terms, what does that mean for companies like Facebook, Google, Twitter, etc.? Because at the heart of this is, are they platforms or are they publishers?
Thanks. Yes. Well, thank you for having me. I think you have to go back to the year that this was enacted, which was 1996, and that was even before any social media platforms had come to being. The first one was in 1997. The idea was that the internet was something new, and two congressmen, one Republican, one Democrat, came together and provided some freedom for the growth of internet service providers. At the time, they were the AOLs and Prodigies. Remember, we had to dial up, although I remember we had to do this dial up. And so the idea was that if we restricted them, then they would, and they were worrying about potential lawsuits, then they would not thrive. They would not want to spend money on growth. They would have to hire too many people to monitor their content. So the the Congress basically said that we're going to give you freedom. We're going to not have you worry about what other people publish on your content. In other words, you don't have to police the content other people publish.
So the conservative magazine, the National Review, recently said of Section 230 that conservatives believe that legislative reforms would betray small government principles, given that the court now has a conservative majority. What kind of ruling could we expect from something like this, and what would be the ramifications either way?
The ramifications are enormous. Interestingly enough, it's both conservative and liberal people. You heard President Biden. Everyone's concerned about Section 230. At the time it was enacted, they did not anticipate it running amok the way it has, for lack of a better word. If the court decides that these companies are not free from liability, then what that would mean is that the companies would have to either monitor every single word that appears on their website, or just say, we're not going to monitor anything. And if they do that, then what's going to happen is things like what the Gonzalez family is concerned with, is that there can be publications by anti-government groups, Nazi groups, all kinds of hate groups, and that's just going to proliferate.
I want to talk about one other case recently in Texas. The Fifth Circuit Court upheld what's known as HB 20. This law prevents YouTube, Facebook, and Twitter from removing or restricting content based on the viewpoint represented in the user's expression. Can you explain how the decision in Gonzalez versus YouTube, how that could ultimately impact state laws like across the country?
HB 20? Yeah. And there's a similar one, actually, you should know, in Florida, where the 11th Circuit has come out the other way. So HB 20 and the Florida law were enacted after January 6th. What happened was President Trump posted some information that Twitter had said was not within their own policing rules. In other words, these content service providers, these social media companies, do police themselves. What happened was they threw President Trump off. As a consequence of that, Florida and Texas both enacted legislation that basically said that that these social media companies cannot regulate any content. Now, the way that plays into Gonzalez is this way. Under Section 230, the key word in the Gonzalez case is publisher. Did YouTube act as a publisher? Google owns YouTube. Did YouTube act as a publisher when they allowed this content in? If they acted as a publisher, they're free from liability. Similarly, the case in Texas, the statute basically says that you can't regulate any content at all. So what Section HB 20 would do would be to remove any freedoms from liability for all social media websites.
And real quick, 10 seconds on HB 20. Any idea on what the 6-3 conservative majority on the high court would rule on this one?
You know, it's interesting. Justice Alito, in deciding on the preliminary injunction, basically said it's time to reconsider this. And what I thought was most interesting about his decision was that he said this is new territory. We have no laws that regulate this, which means that they're not likely to look at precedent. I suspect that they will repeal part of Section 230 either by interpreting publisher more narrowly or getting rid of liability all the way. And in either case, the Internet as we know it is going to be completely different.
Potentially some huge changes to the Internet, social media companies, so forth. Professor Leslie Garfield Tenzer from the Elisabeth Haub School of Law at Pace University. Appreciate your time and your insight.
Thanks for having me.